Whilst we make reasonable efforts to ensure our content is accurate and up to date, information and guidance in this podcast does not and is not intended to amount to legal advice in any particular case. No responsibility or for any consequence on relying upon the podcast material is assumed by Lease or Blacks Solicitors. I'm Ibrahim Dolmir, Legal Advisor at Lease. Today we have Aimee Hutchinson from Blacks Solicitors in Leeds. We'll be talking about an interesting first-tier tribunal case pertaining to trees on park home sites. I've seen that trees are a contentious matter, Aimee, travelling up and down the country, visiting various sites. This podcast today will consider a tribunal decision which dealt with dangerous trees on a pitch. Can you introduce the case, Aimee, and what case will we be discussing today?
Hello Ibrahim. The case we'll be discussing today is the matter of Ronald J. Turner and J.J. Cooper, and the case is important because it determined a site owner's responsibility to undertake the removal of a tree that's within the boundaries of a park homeowner's pitch.
Can you go through some background for our listeners today?
Yeah, absolutely. On the 12th of March 2013, a branch fell off a Scots pine tree in the park homeowner's garden. And whilst that was being investigated, another branch fell off the same tree and broke the gutter of the resident's park home. The tree in question was covered by what's called a tree preservation order, and that's an order made by a local authority to protect trees which bring amenity to a particular area. And before anyone does anything to a tree that has a tree preservation order attached to it, you need to obtain the consent of the local authority. And that's actually because it's a criminal offence to carry out work to what are called protected trees, so that can include cutting without consent from the local authority. In this case, the local authority had actually granted permission for the tree to be cut down and dispensed with a tree preservation order. So the issue the tribunal was determining was who was responsible for the cost of the removal of the tree. And as you say, that can often be quite a contentious issue between site owners and park homeowners.
And what were the arguments that were put forward?
In this case, the written statement was important, and that stated that the park homeowner agreed to keep the pitch and all fences, sheds, outbuildings and the garden in a neat and tidy condition, and that's quite a standard phrase. And the site owner only agreed to keep parts that are not the responsibility of the park homeowner in a good state of repair and condition. So that's the communal areas of the park. So the question was whether or not the removal of the tree that was in the park homeowner's pitch extended to their obligation to maintain the pitch in a neat and tidy condition. The site rules for this park were also of importance. They didn't have any rules that related to dangerous trees, but the site rules did state that trees could not be lopped or pruned without the prior consent of the site owner. Also, the site rules indicated that the park homeowner was responsible for the maintenance of trees, shrubs and plant life. But the site rules didn't actually confine that obligation just to the park homeowner's pitch. So the tribunal held that rule would probably be void for uncertainty because it wasn't clear the extent to which the obligation was placed on the park home owner. And the tribunal then looked at the Mobile Homes Act 1983 and the responsibility of the site owner that's contained in that act. And it was Chapter 2, Paragraph 22D that they looked at, and that states that the owner shall maintain in a clean and tidy condition those parts of the protected site, including access ways, site boundary fences and trees, which are not the responsibility of any occupier of a mobile home on a protected site. But at the same time, the park homeowner must also be aware of their obligations, which are under the Mobile Homes Act 1983, and the relevant part is Chapter 2 and Paragraph 21D, and that states that the park homeowner must maintain the outside of the mobile home and the pitch, including all fences and outbuildings belonging to or enjoyed with it, and the mobile home in a clean and tidy condition.
Right, so what was the tribunal's decision in this case?
The tribunal's view was that you should really look at the responsibility of the park home owner first, so focusing really on the pitch. And once those obligations have been established, the remaining responsibilities will then be with the site owner. And the tribunal determined that the obligation on the park homeowner to keep the pitch in a clean and tidy condition doesn't actually extend to the removing of a tree which needs to be felled because it's dangerous. The only mention of trees in the implied terms refers to site owners, and it places an obligation on them to keep trees in a clean and tidy condition. And the tribunal used that when it was giving its reasoning to explain that the obligation to remove a dangerous tree would be the responsibility of the site owner, as the pitch and actually the tree itself doesn't belong to the park homeowner, it actually belongs to the site owner. And in its conclusion, the tribunal determined that any ambiguity should be resolved in favour of the park homeowner. And really that was because, after all, the tree in question was either planted by the site owner or their predecessor, and it would therefore be unfair to expect the park homeowner to be responsible for the cost of removing the tree.
And do you see any future impact this case would have?
Yeah, I think it's an important case because, as you say, it's quite a relevant issue on sites. And it might be a good idea, if this is an issue that affects you, to contact a qualified agriculturist, which is a tree specialist, in order to ascertain firstly if the tree that's in question is in dangerous condition. But it is important to note that the decision doesn't actually have a binding effect on all park home matters relating to trees. But if the tree is dangerous, regardless of whether or not it's in a specified pitch or in a communal area on a park, site owners may wish to ensure that dangerous trees are removed as soon as possible and as safely as possible, for two reasons. Firstly, the tribunal may hold that the site owner is obliged under the Mobile Homes Act 1983 to remove the tree, as was the position in this case, or alternatively the site owner could also be open to damage to property claims and potential personal injury claims from park homeowners or visitors if there is any damage from the dangerous tree.
Thank you very much, Aimee.
Thank you.